This is part 4 of property. We're going to discuss only the rule against perpetuities. The rule states that future interests are only valid if they must vest or fail by the end of a life in being plus 21 years. When considering the rule against perpetuities and its application, looking at affected future interests, the rule against perpetuities does not apply to future interests that revert to the grantor. On the exam, if the future interest reverts to the grantor, the rule against perpetuities does not apply. Any other interest, essentially consider the rule against perpetuities. It applies to contingent remainders, vested remainders subject to open, executory interests, powers of appointment, rights of first refusal, options. Now, the rule against perpetuities and the future interest is tested as of the time the future interest is created. So consider the rule against perpetuities violation when the future interest is created. So where any interest created by will is tested against the rules of perpetuity as of the testator's death. And here at this creation event there is a vest or fail requirement. If there is any possibility that the future interest will not vest within this time, life and being plus 21 years, then the rule has not been satisfied. Again, if there's any possibility it will not vest or fail within the period specified, life and being plus 21 years, then the rule has not been satisfied. Again, the rule against perpetuities, future interests are only valid if they must vest or fail by the end of a life and being plus 21 years. Now let's look at a couple examples. When you look at 2B for life, then to the first male descendant of B, then to C. Now this violates the rule against perpetuities because the opportunity for B to have a male descendant does not end after he dies, because there is a possibility that the device will neither vest nor fail within a life plus 21 years. It's a violation. Now here you're looking at first male descendant. The key word is descendant. To B for life, then first male descendant of B, then to C. If B at his death has only 2 daughters, and those daughters at the age of 30 have a son, one of them has a son, then technically that is B's first male descendant. Okay? So consider the word descendant. And anytime that's used in the exam, the rule against perpetuities, where there's a future interest that does not revert, consider that as a violation. Example 2 is to B for life, then to B's first son who reaches the age of 18, then to C. Here this is valid because once B dies, his opportunity to have children ends, and so the clock starts. If when B dies he has no children, it obviously fails. But if he has at least one son under the age of 18, that it is certain that that son will become 18 within 21 years after his death. So it will vest. Or it may fail, the son may die. Looking at the measuring life, if no life is indicated, then the life is that directly related to the future interest, such as to B for life, and then to B's children who reach the age of 25. B is the measuring life. If no life is indicated at all, such as to a charity, for so long as it is used as X, then to C, then C's interest must vest within 21 years. This also fails the rule against perpetuity because obviously there's an opportunity for the charity to continue to use it as X for more than 21 years. What is the effect of a violation of the rule against perpetuities? Only the offending interest fails, such as C in the charity above. Now if the grantor's intent is violated by failure, the entire transfer is void. There are exceptions. This is charity to charity transfers, where the interest is passed from one charity to the next. This is not subject to the rule against perpetuity. However, the rule does apply to charity to non-charity transfers. Now that's the analysis that you should go through on the exam. However, after going through a short discussion of that, applicable to the question, you should end with the majority rule. Majority of jurisdictions have adopted a, quote, wait and see stance, where an otherwise invalid interest is considered valid if it does in fact vest within 90 years of its creation. So they have adopted a wait and see stance. And that completes part 4 of property.